Hello, welcome everyone. First, I'm going to pass it over to our language justice team, and then it will be back to me, and then we'll go into the presentation.
Hola a todo el mundo. Primero voy a pasar la palabra a nuestro equipo de justicia de lenguaje, luego me van a pasar la palabra a mí nuevamente y luego empezaremos con la presentación. Bienvenidos, soy Gina, estoy aquí con mis cointérpretes para interpretar entre inglés, español y el lenguaje de señas estadounidense, trabajando con un marco que se llama la justicia del lenguaje.
Welcome. I'm Jenna Liana. I am here today with my co-interpreters to interpret between English, Spanish, and ASL, working within a framework called Language Justice.
La justicia del lenguaje incluye el compromiso de asegurarnos de que todas las personas puedan participar en la conversación y un respeto para los derechos lingüísticos de todas las comunidades.
Language justice includes the commitment to ensuring that all people can participate in the conversation and a respect for the linguistic rights of all communities.
Para acceder a los subtítulos en inglés, haga clic en el enlace que encontrará en el chat. Por favor, avísenos si necesita apoyo en acceder al enlace. Y un aviso, esta sesión está siendo grabada.
To access captions in English, follow the link you'll find in the chat. Please let us know if you need support accessing that link. And a note, this session is being recorded.
La presentación de hoy tomará lugar en inglés y durante la sesión de preguntas y respuestas usaremos inglés, español y el lenguaje de señas estadounidense. Las personas que prefieren escuchar en español o inglés podrán escoger su canal de idioma en unos pocos momentos.
Today's presentation will take place in English, and during the Q&A session, we'll use English, Spanish, and ASL. People who prefer to listen in Spanish or English will be able to select their language channel in a couple of moments.
Hoy estaremos usando la función de interpretación de Zoom, que ya está activada. Verá o un icono del mundo o la palabra más, more en inglés, en la parte inferior de la pantalla. Pulse en más y verá un menú que incluye la opción de interpretación de idiomas o Language Interpretation en inglés. Para escuchar la interpretación, pulse el icono del mundo o interpretación de idiomas. A continuación, elija su canal de idioma. Si está en un teléfono o tableta, haga clic en Listo. Si no puede escuchar la intérprete en su canal, por favor pida ayuda en el chat o levante la mano.
Today, we will be using the Zoom interpreting function, which has already been activated. You will see either a globe icon or the word more at the bottom of your screen. Click the globe or more, and you will see a menu that includes an option called Language Interpretation. To listen to the interpreting, click the globe icon or Language Interpretation. Then choose your language channel. If you're using a phone or tablet, click Done. If you can't hear the interpreter on your channel, please ask for help in the chat or raise your hand.
Ahora vamos a comenzar la interpretación simultánea para hacer una prueba de la función de interpretación. Por favor, elija su canal de idioma si prefiere escuchar la interpretación en inglés o español.
Now we will start simultaneous interpreting to test the interpreting function. Please choose your language channel if you want to hear the interpreting in English or Spanish.
So first, I'm going to speak a little bit in English. Please give me a thumbs up if you can hear the interpreter on the Spanish channel. I'm going to wait and see if maybe Steph or Gina would just want to experiment with clicking on Spanish. Wonderful. Thank you very much. Y ahora voy a hablar
Now
en
I'm
el
going
canal de
to
español.
speak into the
Y
Spanish
espero que
channel,
puedan ver la
and I
pantalla
hope you can give
perfecto
me a
y
hands
se
up.
escucha
Perfect.
la
You
interpretación.
can hear the interpretation.
Usaremos
Great.
interpretación
We will be
simultánea
using a
por el resto
simultaneous
de este
interpretation for the
anuncio.
remaining of this intro.
Ahora,
Now,
todas las personas que
all
prefieren
of the people that
participar en
prefer
un solo
to
idioma
participate in
deben
one
estar
language
en
only
un canal de
should be
idioma.
in their language channel.
Las personas que hablan
The
ambos
people who
idiomas
speak
y no
both
solo
languages,
español,
English
pueden
and
dejar la
Spanish,
función de interpretación
can leave
apagada
the function
o elegir
either
un
off or
canal de
alone,
idioma.
or select
Si
a
usted no
language
puede
channel.
escuchar
If
del
you
intérprete,
cannot hear
use
the
la cajita de
interpreter,
chat para
please
pedir
let
ayuda.
us know via the
Es
chat.
responsabilidad de todos
It is
cuidar de la
everyone's
comunicación
responsibility
equitativa en un
to
espacio
take care of
multilingüe.
communication equity in a
Quisiera compartir
multilingual
unos
space. I would
recordatorios de
like to share a few
comunicación.
reminders for communication.
Si usa un canal de
If you
idioma,
use
por favor,
a
hable
language
en
channel,
ese
please
idioma.
speak in that language.
Haga clic en silenciar
Click
audio
on
original
mute
si
original
prefiere
audio if
escuchar
you prefer to
solamente
only hear
al
the
intérprete.
interpretation.
Hable a un ritmo moderado
Please pace yourself
y
as you
haga
speak
pausas
and
con
pause
frecuencia.
often.
Las personas, por favor, diga su nombre
Please say your
antes de
name
hablar.
before you start sharing.
Las personas que entienden
The
español
people who
habrán
understand
notado que
Spanish may
usamos la
have noticed
terminación
that
e
we
en vez de la
use the
tradicional
E ending
a
or
o.
as opposed to the
Por
traditional
ejemplo,
A or
cuando
O.
dijimos
For example,
bienvenides
when
al
we said
inicio.
bienvenides at the
No es un
beginning.
error de
It is
pronunciación,
not
sino
a
un esfuerzo
pronunciation error, but
intencional
rather
de
an
crear
intentional
espacios
effort to
inclusivos
create
y evitar
inclusive
superponer un
spaces
género
and
en
avoid
las personas.
assuming people's gender.
Quisiéramos reconocer
We
todos
would
los
like to
idiomas que
acknowledge
se
all
usan
of the
aquí
languages that are used
y puede
here
avanzar
today. And
la
you can
imagen,
go to the next slide, please.
incluyendo los idiomas de los
Including
pueblos
the languages
indígenas,
of
las
indigenous
tierras
peoples,
nacidas que
the
cada
unceded
persona aquí
territories that
habita.
every person here
Damos la
lives
bienvenida al
on.
uso de lenguas
We
más allá de
welcome
las que
the
estamos
use
interpretando
of other
hoy.
languages
Favor
beyond
de
the ones being
autointerpretarse
interpreted
si
here.
desea
Please
hacerlo.
self-interpret if you prefer to use
Gracias
that
a los
language.
organizadores
Thank
de
you
este
to the
espacio por
organizers
hacer
of this
posible que
space
estemos
to
aquí.
make it possible
Nos
for
da
us to be
mucho
here.
gusto poder apoyar
We
esta conversación,
are
ya que
delighted to
sentimos una
support this
fuerte
conversation.
solidaridad con el
We are
trabajo
in
que
strong
hacen.
solidarity with the work
Muchas
that you all do.
gracias.
Thank you so much.
Thank you, JE. Good evening, everyone. My name is Stephanie Carroll. I'm the Directing Attorney with Public Counsel's Consumer Rights and Economic Justice team. This series of webinars is brought to you by a collaborative of legal services organisations, including Housing and Economic Rights Advocates, Tzedek, the Legal Aid Foundation of Los Angeles, the East LA Community Corporation, National Housing Law Project, Neighbourhood Legal Services of LA, One Justice, and Public Counsel. Tonight is the third webinar in our homeowner series focused on homeowner association issues. As you know, the session is being recorded in English and Spanish, and we will make these available on our websites and those of our partners. Public Counsel is committed to language justice and accessibility, and we're constantly trying to improve our practices. Please bear with us if there are any delays or technical glitches. Our aim is to be as inclusive as possible. Please let us know about any other language or access needs you have or your community has. When we're sharing screens, you will see the slides and the presenter side by side. You can use the white tab in the middle of the screen as a slider to shift the size of the screen share or the speakers. After the presentation, we will do our best to answer any questions. Please note that this is a Know Your Rights presentation. It's not intended to be legal advice, and if you have a legal problem, you should consult with an attorney separately. Our guest speaker tonight is Gina Giusto. Gina is a senior attorney at HERA and a graduate of Harvard Law School. Prior to joining HERA in 2013, Gina provided advice on landlord-tenant issues at a local legal services program, completed a fellowship at the Superior Court in Alameda County, and spent 2 years representing residents of publicly subsidized housing before local housing authorities. Gina was selected to the California Super Lawyers Rising Stars list in 2016 to 20 for her work in consumer law. The Rising Stars list is selected by peer lawyers and recognises no more than 2.5% of up-and-coming attorneys in the state. At HERA, Gina works on unfair debt collection, wrongful credit reporting, homeowner association issues, mortgage and foreclosure related issues on behalf of Californians in need. And Gina brings significant litigation experience and expertise addressing abuses by homeowner associations. So now over to you, Gina, and thank you so much for being our presenter tonight.
First, I wanted to thank everyone for joining us this evening, especially given how challenging things are at the moment. And I will try to answer a lot of the common questions that I get asked related to homeowners associations in California. There may be more nuanced or more detailed information that could be provided. And if you still have questions after tonight, you can always feel free to reach out to one of our organizations. Our contact information will be available at the end of this presentation. And we're always happy to provide that consultation and information to you at that time. So the first thing that I think is important to know when you're talking about homeowners associations is to understand who the players are in the association. Who are the individuals or parties that you're going to be communicating with when dealing with a homeowners association issue? So the most important party or group of individuals is going to be the Homeowners Association, or HOA as we call it, Board of Directors. That is the group of individuals who have been elected by the members of the association to govern the association, to make the decisions for the association. And if you have an issue, even if it's with one of the other parties that we're going to discuss, at the end of the day, it is the responsibility of the board to make the decision as to what's going to happen with your matter or with the issue that you bring forward. And so I just want to highlight that it's very important. If you have an issue with your homeowners association, you are going to want to bring that to the attention of the board directly. The other very common actor in a homeowners association, many associations have a property management company. The property management company, think of that like the go-between company that acts on behalf of the board and deals with the membership directly. They're usually the company that will send out mailings to the membership, collect regular assessments from the membership. They are likely going to be who you would call if you have an issue and you want to report a problem with the association. And then the property management company typically will then pass on the message or send it on to the board of directors. So, for example, if you have an issue in the association and you do want to make sure that that message gets to the board of directors.
Pardon the interrupt. Thank you for the switch.
So if you have an issue and you want to bring it to the board of directors, you can send that request to the board of directors via the property management company. For example, you send a letter, it is addressed to the board of directors, but you can send it care of the property management company to the property management company's address. The third actor in an association is the homeowners association's attorney. Not all associations have an attorney, but many will at least have an attorney or a firm that they use when there are legal issues that come up for the association. So sometimes if you are in a legal dispute with the association, You may have direct contact with the HOA attorney, but again, the attorney is not making the final decision for the association. It is the board of directors. So if you are needing to get some type of resolution, or if you are trying to get something solved, you still want to address your letters or your requests directly to the board, you can send it care of the HOA attorney. But the final decision is that of the board of directors. And then the next actor is the HOA or HOA debt collectors. So if you have been in a position where you've fallen behind on your assessments, or you are delinquent on your homeowners association account, you may find yourself receiving correspondence or getting calls from companies that the association has hired to collect those debts. And sometimes you may be discouraged from contacting the HOA directly. But just like I mentioned before, if you have a dispute, even with a delinquent account, you can still send those disputes to the board of directors, care of the debt collectors. So care of, and then fill in the blank of the debt collection company you're dealing with. If you want to meet with the board to discuss your account, still send a letter directly to the board of directors and write care of that collection company. And I'm hoping that this is becoming a theme. I think the point is that whatever is happening in the association, the final decision is that of the board of directors. So keep that in mind, because sometimes the issue is that there is a negative or poor relationship with the board of directors, but they have the final decision-making power. So it's very important to keep in mind who will be making the ultimate decision on your issue. And then, of course, the final parties are all of you, the homeowners. You are all members of the association, and you all have a lot of rights and responsibilities, which we're now going to talk about. So the first, in terms of rights and responsibilities, it's important to understand what rules govern homeowners associations. The first set of rules, which most homeowners are aware of, are called the covenants, conditions, and restrictions, or the CC&Rs. These are property use restrictions. They are rules around what you're allowed to do as members of the homeowners association. And these documents are recorded at the county, and they're attached to your property as a member of the association. And you should have received a copy of these CC&Rs when you purchased your property. The second set of rules that you need to be aware of are something called bylaws. And these are rules about how the homeowners association operates, how they run the day-to-day business. For example, when meetings are going to be held and how much notice is going to be provided to the members ahead of the meeting. The third set of rules are called rules and regulations. And I think of these as a catch-all group of rules. These rules are less formal than the above two sets of rules, and they allow the association to address changes that are happening within the association. For example, there may be rules that are only temporary or are seasonal, such as pool hours or ways to access a community area. Those would fall within the rules and regulations of the association. And then the final set of rules it's something called the Davis-Sterling Act. That's the part of the California Civil Code that regulates homeowners associations in California. And that's the main law that we look to when we're worried if there are violations being conducted by the association. So if you're very curious about what rules you need to follow, these are all of the rules that you look to. And at a minimum, I strongly encourage that everyone at least be very familiar with what is in their C, C, and Rs, because those are the main rules that are being enforced by the association. So during this time, when it may be difficult for association members to meet in person, either it's not possible or it's not safe to meet, then there are special rules in place under the Civil Code that allow homeowners associations to meet by teleconference. This is allowed so long as the members are given proper notice, meaning individual delivery notice. In other words, that notice was provided to that member in the preferred method indicated by the homeowner. As well as in that notice, there should be clear instructions on how to participate in that meeting. There should also be contact information for someone who can provide technical support if there's issues connecting or participating in that meeting. And the membership should be allowed to participate in that meeting as they normally would if the meeting were being held in person. So many of you may find yourselves wondering what is going to happen with our meetings currently if there's a declared state of emergency or it's not feasible to meet in person. Likely your association will accommodate that by holding them via teleconference. The other, in a similar vein, the other thing that you might have questions about is what about elections during this time? And just like regular meetings, they can also be done by teleconference so long as two criteria are met. First, that the meeting in which the ballots are going to be counted and tabulated, that has to be done by video conference. And the camera needs to be placed on the person who's counting and tabulating the votes so that you can see it being done. Other than those two forms of meeting changes during this time, the other protection that you have as homeowners during a state of emergency is that the homeowners association is not supposed to bring an action against a member for violating the governing documents. So one of those rules that we just discussed, except for delinquent assessment issues. If the reason why the homeowner is in violation cannot be addressed or prevented at that time, if the violation is something that either the homeowner can't fix because it's not possible to access their unit or it's not safe to access their unit, then the association should not be pursuing that individual homeowner for that violation during this state of emergency. But as I mentioned, that does not apply to delinquent homeowners assessments, which we're going to talk about next. Okay. So I am going to spend several slides talking about HOA assessments, and that's because that's usually the top issue that we see in our work when we get calls about HOA issues. So the first thing I want to remind everyone is the importance of paying your HOA assessments, if at all possible. And the reason is, one, as I already mentioned, the HOA does not have the responsibility to stop collecting against you during this time. And your responsibility to pay those assessments is outlined both under your rules, your CC&Rs, and the law, the Davis-Sterling Act that I mentioned. So it's very important to pay those assessments, because the consequence for not paying your HOA assessments is that the Homeowners Association can take some pretty serious collection action against you, including potentially foreclosure. During the Great Recession, when we saw many families facing hardship and they were trying to decide what bills they needed to pay to stay afloat, we noticed that many families decided to just pay their mortgages and their property taxes because they thought that was the only way that you could face foreclosure. But what a lot of families didn't realize is that you can also face foreclosure by not paying your HOA dues. So I want to emphasize the importance of the dues and discuss your rights, given that that can result in foreclosure. So the first thing, and I think we might be switching interpreters. Ready to go? Thumbs up. Okay. So when we talk about assessments and the importance of assessments, you should be aware that there are multiple types of assessments in a homeowners association. The main three assessments are: first, regular assessments. These are the regular dues that you pay as a member. Usually they are paid monthly, although some associations pay them quarterly or even yearly. But those are your regular dues. Those assessments are not supposed to increase more than 20% from the previous year's assessments. So for example, if last year's regular assessments were $100 a month, then this year's assessments should be no more than $120 per month. Now, if there is a membership vote, if enough of the members in the association votes to increase the regular dues more than 20%, then you might see a higher increase in assessments. But if there's no membership vote, then it can be no more than 20% of the previous year's assessments. The second type of assessment is something called a special assessment, and this is for either unforeseen, unusual, or capital improvements that are done in the association. So think of things like replacing the roof of the association, or adding some type of communal space to the association. And that special assessment can be no more than 5% of the annual budget without a membership vote to make it more than that. And then the final assessment is an emergency assessment, which we may be dealing with right now, given many of the things that have happened to the associations during the fires. These assessments do not require a membership vote, and they can be for any amount as long as it meets one of the following three criteria. Either there was a court order for an extraordinary expense, or there is some type of maintenance that needs to be done because there's a risk to the personal safety of the members. Perhaps the unit that you live in is unstable, or balconies are falling down, and there's a risk to personal safety. That would be an emergency assessment. Or there's an extraordinary expense that could not have reasonably been foreseen by the HOA board. Then they can pass large assessments without any membership vote. And as I mentioned, foreclosure is an option if you fall behind on your HOA assessments. So I wanted to take the time to explain that a little bit more in detail. If your assessments, just the assessments, not fees or interest or collection costs, but just the assessment portion, if you fall behind by more than $1,800 or more than 12 months, then that triggers the right of the association to potentially foreclose on your unit. So at a minimum, if you're struggling right now, try and keep your delinquent assessment portion of your debt below that threshold, below $1,800 or less than 12 months delinquent. Just so you're aware, the HOA is required to accept any payment you make. They are required to apply those payments first towards the delinquent assessment balance before any other amounts, before they pay for interest or late fees or collection costs. The payments have to be applied to the assessments first. And they do that so that you can avoid foreclosure. It allows you to stay under that threshold when you make those payments. But I do want to acknowledge that if you fall behind, the HOA can charge some pretty stiff or expensive fees and costs. So they can recover the reasonable costs incurred in collecting those delinquent assessments, meaning if they have to hire a collection company to pursue those assessments, they can charge you for those collection fees. They can charge a late fee of 10% of the assessment or $10, whichever is greater. So for example, if your assessment is $200 a month, they can charge you $20 every month that you're delinquent. And then 12% interest on those delinquent assessments. In terms of insurance, you may have some questions right now about the coverage on your particular unit. And I just want to let you know that your HOA should have provided a summary of the association's insurance coverage. They provide that every year. And if you did not get a copy, I strongly recommend that you reach out to the association and ask for a certificate of insurance and the declarations page. And those two items will tell you what is covered under the HOA's insurance policy. I just want to remind everyone, however, that personal property is typically not covered under the HOA's insurance policy. So many of you probably have your own insurance for your individual unit and all of your personal property. So you may be looking at two different sets of policies. And then the final thing I wanted to touch on before we move on to questions is that right now there's going to be a housing shortage. And some of you may be inclined to rent out units in your association. And you may be having issues with the board in terms of rentals. Now, the board should not unreasonably restrict renting out units in the HOA, but there are some things they can restrict. For example, the HOA can cap the total number of units, permissible unit, rental units, to 25% of the entire HOA. So if all your neighbors are renting, then you may face challenges in renting out your unit because too many members are renting out units in their association. And one other restriction or issue that you should know about for rentals is that if new restrictions are passed by the HOA, if those restrictions did not exist at the time that you purchased your unit, then you should be exempt from those restrictions. But if those restrictions were passed before you purchased your unit, then you need to comply with those rental restrictions. So if you have an issue with a specific restriction, you may need to figure out if that was passed before or after you purchased your unit. Okay, so these are all of the organizations you should feel comfortable reaching out to. If you have HOA questions, certainly feel free to reach out to our organization, Housing and Economic Rights Advocates. We work on HOA cases quite a bit throughout the state. And now I'm going to open it up to questions, as I'm sure there are many in the chat. And others may want to raise their hand and ask questions.
Hi, Gina, this is Steph Carroll. I just wanted to say to everyone is our preference is for you to put your questions into the Q&A or the chat. I know there's already been a couple in the chat and I will ask those to Gina in a moment. You can put your questions in either English or Spanish. If you prefer to speak or sign your question, you can raise your hand and we'll give you permission to open your mic or video in that instance. I would just ask that a reminder that this is a Know Your Rights session. It's not intended to be legal advice. So if you can keep your questions of a general nature, that will help us. If we can't answer any questions tonight, and it's the kind of question that we can take back, we can put together a FAQ that can go on our websites and those of our partners. And before we get into questions, if folks have feedback about the presentation and the format or anything like that, I'm going to be putting an email address into the chat for everyone to see. And you can make any comments you want to this email address, which is gguidetti@publiccounsel.org. That's GGUIDETTI at publiccounsel.org. Okay, Gina. So first off, we have a couple from the chat, but let me do the Q&A ones. Okay. First of all, what are the general duties of a HOA with the fire situation now in terms of cleaning common areas, etc.? And do they have to email all members with updates?
So in terms of the responsibility of the HOA, they're still responsible for maintaining the common areas and think of it as the outside structure. But in terms of fire damage within the unit, it's likely that that is the individual homeowner's responsibility. And then email updates, to my knowledge, there's not a requirement that they send those email updates, but that's an excellent question or topic to bring up at the next HOA general meeting, because I'm sure that many of the members would have questions or like more frequent updates on what is happening.
Thank you, Gina. Okay, the next question we have is, what types of things are usually covered by the HOA's insurance?
So again, some of this is insurance law, which I will not say I'm an expert, but in general, when it comes to homeowners associations, typically the policies are going to cover the structure. Think of the outside walls of your unit. If the roof has been damaged, replacing the roof, or some other structure has been burned down, then that would apply. But things that happen within the individual units are typically going to be covered by individual homeowners policies. And this is a very challenging area because sometimes it's hard to figure out what is caused by some issue that's happening outside the unit that's impacting the inside of the unit, outside, forces impacting the inside of the unit. So it's not always a clear-cut answer. But the more simplistic description is the things that happen outside the general building or the common areas, that's usually the things that are going to be addressed through the HOA's insurance policy. And the other thing you should realize is that your CC&Rs sometimes will dictate specifically what type of coverage your HOA is supposed to have. So you should also check your CC&Rs for that answer on an individual basis.
Okay, the next question we have, Gina, and this may be straying more into insurance than is in your wheelhouse, but maybe not. So please let us know if so. But the next question is, could you elaborate on how the HOA's insurance and homeowners insurance work in the case of a total loss?
I think that might be more of an insurance expert's answer, but I believe the way I would think about it is the structure and the rebuilding of the structure, that's likely going to be all the HOA's policy. But all the personal property within the units, that is the individual homeowner's policies. So there's probably going to be claims on both of those. It's the association that's going to be making the claim on the general HOA policy. But all the stuff on the inside, the personal property. So we're not usually talking about the things attached to the unit. So the cabinets and the plumbing, all of that's usually covered in the HOA's policy. But you might have an association that has a very bare minimum policy that does not cover those things. So it's a little difficult to answer that question without saying the policy for your individual unit, which we could take a look at if you're really concerned.
And Gina, this question, if you look in the chat, that this question was followed up by somebody with the initials RL. So I just want you to look at that in the chat and see if you have anything more that you think you can add at this point. And if not, we'll go to the next question, if you can see the chat. It's at the very bottom of the chat.
I feel like this might be a question. This is more of a insurance coverage expert question.
Okay.
Which I can't remember if we have a presentation, but I believe there's some materials that we're pointing folks to for the insurance question.
Yeah, we were pointing people to the Beverly Hills Bar Association presentation, but I think there are other ones, and we'll try and advertise any that come up on our website. So going to the question above that, Gina, can homeowner associations continue to charge full fees to homeowners if people have destroyed properties and have left the area?
So technically they can still charge the full assessments. I think the counter argument to that is that the assessments are meant to cover the ongoing costs to run the association. So if that suddenly changes, there's no association to maintain, you're not paying your usual vendors, then ideally your assessments, your regular assessments should reflect that. But it could be that the association is collecting your ongoing assessments as they've been approved, and they will just simply put those assessments that they're collecting in your HOA's reserve account and then apply them once those bills come forward. Because I'm guessing that the association, while they may not be paying their regular vendors, or at least not all of them for certain reasons, they may have extra costs for running the association that they need to use that money for. So it's not an easy answer. But if there's not extra expenses and the association is no longer paying its vendors or providing the services, then I do think that there needs to be something but put before the board to ask them to recalibrate the assessments to acknowledge that. But it usually happens once per year when they're passing the new assessments. So it's you might have to wait until the next time that they're evaluating the assessments.
Okay, now I'm going to move to the Q&A box, Gina. So I don't know if you want to pull that up on your screen, because there are a couple of questions where I think I might need to fill some things in for you, or you might need to fill some things in for me. We have 3 questions by one person. The first question is, how does a HOA determine the adding of 10% in SF? And I'm not really sure what that means. Maybe you do. I don't know if it's referring to San Francisco, and if so, that isn't related to what we're talking about here. But if you know that it's related to something else, Gina, let me know.
I don't know what SF stands
square
for.
footage. Square footage. There we go.
Square footage. Got it. Okay. So some associations will charge assessments based on the size of your unit. So you have a pro rata share of the assessments. It's sometimes not equal across the board. They are allowed to do that under the civil code. So that could be what's happening in your association if square footage is actually related to the difference in assessment amounts.
And if that question is directed at rebuilding and increasing the square footage of the building, I think that's something that's not within the scope of this. There is a question about, how does the homeowner association apply for FEMA? And again, I think that's probably a question for FEMA and not a question for us.
Correct.
And then there's a question about, do all the homeowners of a HOA have to opt in for phase 2? So Gina, just in case you don't know, so I think what this relates to is there are different phases of clearing lots. There's a phase related to clearing out hazardous materials, and then the county, LA County, have a scheme where they are going to clear the lots so that they are then buildable lots, and you can opt into that procedure. So I'm not sure that you're going to have an answer for that. I think that the LA Public Works folks will have an answer for that, but I don't know if there's anything you want to say on that, Gina, and if not, we'll move on.
I don't know the answer to that. I'd have to look at the interplay of the rules between that and what's required under the Davis-Sterling Act. But I would imagine that the board is going to have a lot of authority to make that decision on behalf of the membership in this scenario. So I would not be surprised if they did not have to get all members individually to opt in. But that's more of my instinct and not something that I would say is absolute, because I'm not positive on this one.
And maybe that's something, Gina, we can talk about later and try and figure this out, so we can post that somewhere.
Yeah.
Okay, the next one, Gina, I hope you're following along, is from somebody with the initial S. again, it might be more of an insurance question, but if you think you can answer it, do you want to say the question and then answer it, or just let me know if you don't think you can?
So it looks like the question is, my walls and insurance provider is saying that they are not responsible for insulation. Is there a way to get the HOA to remediate? So the first thing I would recommend is asking to meet and confer with your HOA board over this issue. It's going to come down to it's a battle of the two insurance providers, really. And you can try and, if you cannot come to some type of resolution with your HOA by meeting with the board, then you could theoretically sue the HOA. But I would not recommend that option to force the HOA to do it unless you're very confident that your insurance provider is correct.
Thank you, Gina. The next question I think probably relates to the same thing as phase 2 earlier. It's the HOA FEMA help with debris removal. Do all unit owners and the homeowners association have to submit a right of entry? This is to the Army Corps of Engineers, or does just the HOA submit the right of entry and not the unit owners? And again, I think that's a similar question to the one we had before. It might end up being exactly the same question. And we will look into that and try and post something on our websites. The next question is the HOA responsible for under-insuring the property? And I'm not sure if you can answer that, but that's the question.
If this question means, or if by this question you mean, is it possible that the HOA is underinsured when they should have more coverage, then what I would suggest is that you look to your CCNRs to see if they indicate how much coverage is required by the association. And if the policy does not meet that standard, then I would say the association is underinsured. And yes, it is the responsibility of the HOA. They're at fault for underinsuring.
And this appears to be our last question, at least at the moment, is this again may be a bit specific. In rebuilding, where owner has walls in insurance, I presume, does the HOA only, I think the answer is the HOA only responsible for dry walls between units? And does the homeowner have to do all the interior walls? I hope that question makes sense to you, Gina.
It's so some of this is going to be an insurance expert's question. But in general, if it's walls in, then it should include, I believe, all of the things that are affixed to the unit. So I would guess that it would include the interior walls. But again, this is a good question for an insurance expert.
Okay. Unless we have, I'm just looking in the chat to see if there are other questions. Thank you, Amy. From Tzedek. So we have another legal services person who has also had several HOA cases with insurance questions. And I think maybe, Amy, what we can do with Gina is to try and put together an FAQ if we can find insurance experts and take some of the questions from today to try and do that and get something up on our websites within the next week or so. Amy, does that sound okay to you? You can put in the chat if so. Great. Okay, that's what we're going to do. So thank you so much, Gina, for that amazing presentation. And forgive me, I think I butchered your surname earlier, but thank you very much. Gina is from Housing and Economic Rights Advocates. They're based in the Bay Area, but they do cases across the state. And we have been very lucky to have her expertise. I'd also like to say thank you to the other partners. All of them are listed here. And a special thank you to our language justice team, who has provided excellent interpretation for everyone tonight. So thank you, everyone, and good evening.